is, my lord, there before your lordship. And my lord,
Yes.
he has not shown a single provision. He only is saying
That the writ petition is not maintainable.
He
He
is
has
saying-
not addressed on merits. That is the first point that
first
you have
point,
to
that I'm
overcome.
saying, my lord, when the
Then only you can go into the
yes, my
merits.
lord. Yes, my, I'm not coming back, my lord. He's saying that when I am declaring a fraud, this is my lord's order, and prior to that, Justice Bhattacharya, a lot of orders are there, even in this cases also, my lord. So, if your lordship, well, there is no such thing that the bank is declaring me a willful default or a fraud without issuing a show cause notice. That comes under the encompass of the principles of natural justice, where this honorable High Court has a wider jurisdiction. Only these things are there when they exceeded the jurisdiction and the principles of natural justice violated. However, they also exceeded the jurisdiction when they rely upon the same report. And they also, I cannot go to the RBI that they are exceeding the jurisdiction of the NCLT. So I am coming to the RBI. There's the issue, are the two issues are there. And second, the natural justice.
In that case, what is the requirement making RBI a party?
RBI can take a serious concern against them and should ensure that they should comply with
For
that
that
directive.
reason, they have to approach RBI, and there is a specific provision in law.
No, but then if the RBI circulars are there, you are bound to act in accordance
ma'am.
with the same.
Yes,
Is
ma'am.
it your case that you have issued an opportunity of hearing?
Yes, we have done everything. We have complied with. But so far the point of mandate, so far the point of law is concerned. I have taken out that.
He misleading, but here not.
The affidavit,
আমাকে
point of
বলবেন।
law is not required to be highlighted. You can, point of law is always available.
ma'am.
You can make submission
Yes,
anytime.
but so far
There
so
is
far
no.
this
What have you disclosed in your affidavit regarding the giving opportunity of hearing?
I'll satisfy you.
Sure.
And
You have mentioned it.
yes,
Nothing
Alright.
is there.
Let him say it is his affidavit. He will say.
I'm sorry.
On that point, my lord, so far the maintenance is concerned, and may I be allowed to place before you? Only I have only one book. May I be allowed to read it and hand it over?
What thing? Judgment?
No, my lord, the statute.
All right.
The Reserve Bank Integrated Ombudsman Scheme 2021, where the Ombudsman, Deputy Ombudsman shall consider the complaints of customers of regulated entities relating to deficiency in service. And then, my lord, who are the regulated entities? If I come back to the definitions, regulated entity means a bank or a non-banking finance company or a system participant as defined in the scheme, or any other entity as may be specified by the Reserve Bank for time to time to the extent not excluded under the scheme.
It's all right. What are the steps you've taken in compliance of the Supreme Court's order in Rajesh Agarwal?
My lord, again, my lord, that is a matter of merit. Report.
Which rule you are using?
Scheme
You are saying deficiency in service. It is not a deficiency in service.
There are other.
That is also there.
And if your lordship kindly takes up their applications,
Affidavit.
their applications,
Writ petition.
Yes.
If
your lordship kindly comes to that they have disclosed.
Please.
Page 71.
Yes.
My letter.
Your letter 24th May 21.
Yes. Letter of show cause.
Petitioner is Sushil Kumar Bhansali.
Yes, my lord.
Yes.
Before declaring him as willful defaulter, I have issued show cause. To which, my lord, they have replied, which is at page 75.
Yes.
In reply to that, my lord, I have given reply at page 80.
All right.
Then, my lord, I have given him opportunity to.
This is willful default.
Sir, আমাকে তাহলে আপনি মামলাটা করুন, আমি চলে যাই।
I'm just quoting you. This is
yes.
If your lordship kindly comes to page 85 once.
Yes.
Subject notice seeking written representation against the preliminary decision of committee, identification of willful defaulter, no non-cooperative borrower notice. they did not give any representation to the bank. Thereafter, my lord, I have sent the decision to the review committee, which is at page 87.
Where is the order of the identification committee?
Kindly comes to page 87, my lord. That is the minute. By which he was declared as willful default. My lord, thereafter, he has taken a point that
Did he approach the review committee?
no.
No.
His only contention is that the forensic report issued by the auditor was dismissed by the NCLT. If your lordship kindly takes up my report in the form of affidavit.
1 minute. Page 87 is the order of the identification committee.
My lord.
Thereafter, there is a provision to approach the review committee.
Yes, my lord, this is the recording of review committee.
Where?
Oh, I'm sorry.
This is the committee for identification of willful defaulter.
Identification of willful defaulter. Review committee was ওটা কথা আমরা আমাদের রিভিউটা আমাদের এফিডেভিটটা বার করো সেম
Well, I'm not challenging willful default. I'm challenging the fraud, my lord. This is wastage of your lordship time, my lord. Precious time, my lord. I'm saying here I'm not a fool, my lord. This annexing
All
that
what has been shown by your learned friend is regarding willful default.
willful default. I'm challenging the
And my
fraud. My fraud is different circular and willful default is separate.
and my lord, fraud was on the basis
Please,
of
he's wasting time.
on the basis of what case I have.
I cannot annex the circular show cause notice and say I have not been issued a notice. Is this possible? What my learned friend is, I don't know what he's where he's moving. I
Is
think
there any document relating to fraud?
fraud declaration, but this is entirely this is willful default, separate entirely.
To find out those documents, but
He's my confused
no,
my lord.
I
I
have
think
not
he's
been
trying to confuse the.
Why are you wasting the court's
Wasting the-
time by
by
showing the
completely-
willful default provision?
point of willful defaulter as well in his
No,
No, he
I'm
says
challenging only
fraud.
fraud, my lord. I'm challenging only fraud.
kind comes to the
Fraud and willful
application.
default completely, my lord. I'm not so fool, my lord. I've annexed the notices with the petition and I made a prayer that no notice been shoved upon me, my lord.
His only contention is that the order of forensic report was discarded by the
That
learned
is my
NCLT.
lord. But that may be
He kindly comes to
In your affidavit,
page 11, my lord.
have you annexed any document to show that you have given an opportunity of hearing
my lord.
prior to declaration of fraud?
Nothing. My lord.
Then what remains in the writ petition?
Wasting
Why
your time,
waste
my lord.
this
Please
court's
say a
time?
simple thing. He's not
In that
asking.
case,
He's
I'll
no
restrict
opportunity
myself
given,
to
my
the
lord.
point of maintainability.
Please come. The petitioner is aggrieved by the act on the part of ICICI Bank in declaring the petitioner's account as fraud without granting any opportunity of hearing to the petitioner. Stop. Violation of natural justice has been pleaded. Stop. It has been submitted that the direction passed by the Honorable Supreme Court in the matter of State Bank of India versus Rajesh Agarwal and others has not been, the reporting টা একটু দেখে নেবেন তো অন্য অর্ডারে আছে, has not been complied with. Stop. Learned advocate representing the ICICI Bank raises a preliminary issue with regard to the maintainability of the writ petition. Stop. আপনি একটু ইয়েকে জিজ্ঞেস করে
There
নেবেন।
are a number of judgments on that. If your lordship say, I can show that.
আচ্ছা, The learned counsel representing ICICI Bank refers to the judgment delivered by the Honorable Supreme Court on 24th January 2025 in special leave petition within brackets C numbers 2625/2627 of 2025 in the matter of S. Shobha versus Muthoot Finance Limited. Wherein the court held that normally mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. Stop. It has been submitted that there is no public duty or public duty element in the instant case. Stop. The judgment. Now, the Honorable Supreme Court clearly laid down that the writ petition against the private bank. Now, the writ petition, that a private company carrying on banking business as a scheduled bank cannot be termed as a company carrying on any public function or public duty. Stop paragraph. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a public thing, do a particular thing, comma, it does not possess the attribute of a statutory body. There is no public law element involved in the instant case. Paragraph. The learned advocate representing the petitioner stress on the fact that the report of the forensic auditor, which was not which was dismissed by the learned NCLT, has been relied upon the bank for declaration of the petitioner's account as fraud without an opportunity of hearing being granted. Stop paragraph. It has been submitted that the ICICI Bank is a member of the consortium bank, in respect of which a separate writ petition was moved by the instant petitioner, being WPO number 1364 of 2023. Stop. The said writ petition was disposed of by the court on 24th February 2025. Stop paragraph. Despite issuance of the point of maintainability of the writ petition before this court, the learned counsel for the ICICI Bank submits that no opportunity was given to the petitioner prior to declaration of fraud. Stop. However, with regard to declaration of the petitioner as willful defaulter, all opportunities were provided. Paragraph. The Reserve Bank circular dated 10th March 2025 being has been placed before this court. Stop. The Reserve Bank has made it clear that all regulated entities are required to comply with the master directions published by the Reserve Bank of India in respect of treatment of willful defaulters and fraud, and any non-compliance shall be viewed seriously. Stop paragraph. The Honorable Supreme Court in the matter of Rajesh Agarwal has reiterated that the principle of audi alterum partem is required to be complied with by the bank prior to declaration of the account as fraud. Stop. Next. As it appears that there has been a statutory violation by the ICICI Bank as well as violation of the direction passed by the Honorable Supreme Court in the matter of Rajesh Agarwal, within bracket Supra, comma. The court is minded to interfere in this matter. Stop. The ICICI Bank is directed to take steps strictly in terms of the master directions published on fraud by the Reserve Bank of India and in line with the judgment delivered by the Honorable Supreme Court in the matter of Rajesh Agarwal, within bracket Supra. Stop. The writ petition stands disposed of.
Well, declaration of fraud be set aside, my lord. Your lordship, they have already declared me, my lord.
Where is that impugned order?
But they are not showing with that affidavit, but they have admitted in that petition, but nowhere it is available. But can you see their affidavit, my lord? But it is not available with me, man. I came to know from the Axis Bank, my lord, that they have declared me a fraud, which is there at page 99 of my petition, my lord. At page 99, my lord. Still, they have not annexed with this petition also, my lord.
In affidavit, my lord, we have disclosed that we have complied with all the statutory
Page 9, let him,
my
let
lord.
my
And
lord
my
is
lord,
in
thereafter only we have declared him as a fraud.
Well, page 99, my lord, lender requested the ICICI Bank in the mid-in law.
Yes, to share the
Yes,
rationale for
ICICI Bank
its fraud
classification,
class.
ICICI Bank by email dated 26/11/20.
The declaration of the petitioner as fraud by ICICI Bank stands set aside.
I'm highly grateful, Mike. Highly grateful.
Yes. No.
I'm grateful.
Call the circuit bench matter.
My lord, we are for the petitioners. As on the previous occasion, you might recollect, my lord has ordered that the matter to be directed on 10th of April 2025. My lord, I guess there had been some problem.
Huh? Can is not in file. আমি বুঝতে পারলাম না কি বলছেন। Application?
My lord, that I have to take instructions for, my lord. Here only, my lord. I had mentioned on the previous date upon
Where
mention.
did you file it, in the circuit bench?
No, my lord. The contempt application had been filed here on the Jalpaiguri circuit docket, and the writ petition was there in circuit bench, my lord. Upon mentioning
And the connected application.
connected application, my lord, upon instruction I have to get, but from what I can recollect is that application is there itself,
In the circuit bench.
my lord. That was that application for condonation of delay, which, my lord, the council has cleared on the previous date. It was,
Condonation of delay in what? In the writ petition?
my lord, my lord,
The writ petition must have been disposed of. That is the reason CPAN has been filed.
my lord, my lord.
Or is it pending?
No, my lord, it is
Writ
not
is
pending,
disposed.
my lord. And for the order that was passed on the writ petition,
No, that is all right. Violation is all right.
my lord, due to previous change in briefs from several advocates, my lord, there was a contention that the letter was not dated, the representation.
Please come. আপনি এটাকে অ্যাপ্লিকেশন হিসেবে ফাইলে দিয়েছেন কেন? এটা কি লিস্ট করেছেন? The matter has appeared in the list for correction of the order dated 20th March 2025. এটা কি কারেকশন বলবো না কি বলবো বলুন তো? এখানে এই এটা ফাইলে নেই, কারেকশনটা লেখা ordered that the interim application copy can 1 of 2023 filed in WPA 457 of 2022 is not in file. Stop. The department is directed to tag the file with the contempt application CPAN at the earliest. Application বলে দিয়ে চালিয়ে Item number 1, the writ petition has been dismissed. Item number 2, the PWD has been directed to the petitioner. The admitted dues along with interest of 7% per annum calculated on and from the date of successful completion of work till the date of actual payment. The earnest money deposit and the security deposit shall also be released along with simple interest at the rate of 7% per annum calculated on and from the due date till the date of actual payment. And the payment shall be released within a period of 4 months. If the same is not done, then 2% additional interest have been imposed. Item number 3, the writ petition has been allowed. The writ petition has been dismissed. Yes.
For the petitioner, the matter has come up for certain corrections.
What is the correction?
It had come automatically. It came automatically.
What is the correction? Jana Babu, এটা কি Please come. WPA number. 18 হবে। Yes. Next.
My lord, the matter will come up on 10th April.
Everything is all right. Only the writ petition number was wrongly recorded. Instead of 2018, it was recorded in 2028. Six.
Well, I don't know much. I'm for the petitioner. This matter relates to the GST amnesty scheme. The respondent have paid the GST amount.
Very well. Relief sought for by the petitioner has already been allowed by the authority. Stop. Next, in view of the above, the writ petition stands disposed of. Next one is also the same.
The next time.
আচ্ছা এটা লিখে দেবেন কিন্তু learned advocate for the petitioner submits that.
May it please, my lord. My lord, on instruction, my lord, may I place the written instruction on the court?
Writ petition is of 2025.
Yes, my lord.
Why is it being withdrawn?
My lord, as per the client's instruction, my lord.
Client's instruction, is there any reason for such instruction? You file it in January and then you withdraw it.
Lord, his plan was cancelled, my lord, so it has been instructed to withdraw.
Plan has been cancelled. What plan?
Lord, I have given the written instruction. My lord. Yes, sir.
The program of Sunil Agarwal. Who is Sunil? Anil is the petitioner. Sunil is the petitioner also.
Yes, there are 5.
Anil Sunil. Lookout circular. Very well. Please come. Learned advocate for the petitioner submits that the petitioners do not intend to proceed with the writ petition any further. As the program of Sunil Agarwal, one of the writ petitioners,
My lord.
has been cancelled. Stop. Prayer has been made to withdraw the writ petition. Stop. In view of such submission, the writ petition stands dismissed as withdrawn. Written instruction taken on record.
Much obliged.
Grateful.
But I'm for the respondent number 2.
My lord, I am appearing on behalf of the petitioner, my lord. Lord, this is my affidavit of service.
Yes.
My lord. My lord, in this matter, my lord, I have preferred this application before your lordship on against an order passed by the Honorable State Commission, my lord. After passing 2 orders of the National Commission, where the National Commission has reiterated their version twice and upheld the proceedings which has been continued in the District Consumer Forum. My lord, surprisingly, the State Commission on one occasion has not interrupted or intervened in the order and directed the District Commission to proceed with the proceedings in accordance with law in light of the observation of the
Honorable National Commission.
Who are they? Who are they? These people standing behind you?
They, my lord, they are the petitioners.
Tell them to sit, and their presence is not required.
I told them, my lord, several times, but they are
Tell
very
them
much.
to sit somewhere.
আপনারা বসুন, my lord, বসতে বলছে। My lord, through the Legal Services Authority, my lord, they has come up to.
Yes.
Now, my lord, now, if your lordship kindly sees the order of the Honorable National Commission on page number 35, my lord, very clearly it has been mentioned, my lord, that on page number 39 is the concluding portion, my lord, that respectfully following the law laid down in the aforesaid judgment of the Honorable Supreme Court, as the National Commission has no jurisdiction to entertain any revision under section 21B of the Act against an order passed by the State Commission under section 27A of the Act in execution proceedings, we dismiss the present revision petition as not maintainable, leaving it open to the petitioners to seek appropriate remedy in accordance with law. Now, my lord, if your lordship comes to running page number 20,
What is the exact relief you are claiming?
lordship CC,
Completion certificate
completion certificate,
not
lordship,
being issued.
not being issued, lordship.
Now,
Lordship,
completion certificate has to be issued by the competent authority.
competent authority.
What will these people do?
Now, my lord, that is why, lordship, the District Consumer Forum, when proceeded with an execution proceedings, that has been stalled on the ground that 3 applications are pending against the order, challenging the order of the building tribunal before the Honorable High Court, and the district consumer would not take any harsh steps. That is the technicality, my lord, in this case. Lordship, can it be, can the State Commission directs in such a manner to stall our proceedings when the National Commission has not interfered, not intervened, not passed any order? My lord, kindly considers where, my lord, the National Commission has, they have preferred before the National Commission on that point of time in which they are standing today as well. Absolutely on that point of time, National Commission did not interfere. Even though, my lord, State Commission on the first instance,
What according to you should be done? They
My
should
lord-
be directed to
my
the
lord, in
authorities.
accordance with law, the District Consumer Forum will proceed in accordance with law.
What does in accordance with law mean?
My lord, to take harsh steps so that the CCB made available to them, because they have intentionally stalled these proceedings, my lord.
Try to understand
My
one
lord,
thing.
my lord.
CC is not being given. Possibly,
My
I
lord.
do not know what is the fact,
My lord,
because of certain defects or discrepancy in the construction
my
that
lord,
has been made,
my lord,
for which the the building tribunal was provision was invoked.
my lord,
Right.
my lord.
Thereafter, challenging the order, civil revision or writ petition, whatever is pending before this
My
court.
lord, my lord,
At this juncture,
my lord,
can the consumer forum,
my lord,
whether it is the state or the district,
my lord,
pass order for grant of CC? It cannot be.
my lord, I will take few minutes, my lord. Page number 27. It will be clear from your lordship what are the order, what the first order. The order was the OPs are directed to pay a sum of rupees 5,000 towards damages, delay in respect of delivery of possession, a sum of rupees 9,000 towards house rent for the period from April to June, so and so 1 lakh rupees for the 1 lakh rupees for compensation, and a sum of rupees 3.5 lakhs rupees towards cost and expenses, proposed construction, and cost of rupees 2,000, totaling to 4,66,000. This was the initial order, lordship.
Has
OPs
this
are also,
payment been made?
my lord, I'm coming, lordship, made. The OPs are also directed to hand over KMC tax clearance certificate and completion certificate and copy of plan and all other relevant necessary papers for mutation within 1 month from this date. My lord, now everything has been complied. Challenging this order,
Everything
Lord-
has been complied.
lordship, parts, 7 except what I have come before your lordship. 7 except what I have come.
Completion
Now,
certificate.
lordship, they challenge this procedure.
7 except the completion certificate.
Completion certificate.
The tax clearance has been given.
Lordship, tax clearance has been given, lordship. Now, lordship kindly comes to now they have preferred this application challenging the
Are you
order
sure that the tax clearance has been given? Are you sure?
tax clearance certificate has not been given. In
Then-
relation to KMC, nothing has been provided.
Why do you say that it has been given?
Lordship, CC has not been given, tax clearance certificate has not been given. Now, lordship kindly comes to the order which has been passed by the State Commission in while challenging the order when the OPs preferred the appeal. In view of the discussion above, we do not find any merit in the revisional application. The petitioner shall continue to remain on bail. Amount of 5 lakhs deposited pursuant to the interim direction dated 24/12/14 shall not be released till the disposal of the proceedings. Thereafter, they preferred, my lord, subsequently, my lord, stay against an order. They against an order. They again against an order of the EA proceedings, my lord. They preferred a application before the State Commission. What the State Commission said? We have heard the submission made by both sides and perused the papers on record.
Which page are you
My lord,
reading?
this is running page number 31 is the order, my lord. The National Commission's order. Thereafter, State Commission's order starting from P4, page number 31. This appeal under section 27A of the CP Act is directed against the order number 41 dated 22/06/2015 passed by the Learned District Forum, Alipur South 24 Pargana in EA so-and-so, whereby the Learned District Forum recorded that JDS did not comply with the order of the Honorable National Commission and proceeded under section 27 of the CP Act. Matter to the Learned District Forum with the direction to follow the directive of the Honorable National Commission dated 13/4/2015. The written objection has been filed by the appellant against the miscellaneous application.
Yes, I have read it.
My lord, the concluding portion is the last paragraph. That point of time, my lord, the building tribunal proceedings was pending before the Honorable High Court. At that point of time, there was only difference was what? Execution in execution proceedings, warrant was issued. In the furtherance to this.
I have followed.
Your
Tell me one
lordship
thing.
kindly come to
My
last
lord, only
paragraph
1
of
minute,
page
my lord. Only 1
46
minute,
and
my lord. Only
47.
one. Kindly.
The answer is there, my lord.
The answer is
1 minute, my lord. At that point of time, State Consumer District Commission has not interfered, despite of the fact that there was a proceedings pending before the Honorable High Court. At that point of time, nothing was matured in the Honorable Court. Till then, the status is the
Same.
CO is pending. They have intentionally kept it pending.
Are you a party over there?
I am a party.
What steps are you taking for
I have
getting it
taken,
heard?
lordship. I have taken for hearing, lordship. The matter was taken up before the Honorable Court once, 3 months, 4 months back, lordship, when the determination was with Honorable Justice Prosenjit Bishwas, my lord. Thereafter, determination got changed, lordship. We prefer this application. Now, my lord, kindly considers that this order passed by the State Commission in the order, which is an order dated 7/9/2015. On 7/9/2015, the State Commission passes this order. Thereafter, the State Commission passes that not to take any harsh steps on. In the meantime, they have preferred a application before the National
Followed
Commission.
it. Yes.
My lord,
The commission did
entire
not.
checkered history has converged to a focal point, that is issuance of completion certificate. Now, why it could not be given by corporation, and how can we be held responsible for the issue? Your lordship will get every answer. Last paragraph, page 46.
But they are not proceeding with the
Now,
CO
advocate
application.
for OPs drew our attention by
Intentionally,
showing a
they are
letter
keeping it
Sir,
pending.
why are you not
Lordship.
proceeding with it?
issued by them.
Party is enjoying an interim order, he'll go and press the matter. It is never done.
No, lordship.
It is for the other party who is suffering an order to press it. So
Lordship.
why are you not taking steps?
Lordship, I shall.
Your client is coming to court every day, see their age.
Lordship.
Now, one learned advocate for the OPs drew our attention by showing a letter dated such and such to 15. issued by them to the complainant that they had paid all outstanding taxes of premises number such and such and collected the no outstanding certificate from the assessment collector such and such. And they also collected hearing notice in the name of complainant issued by KMC. But unfortunately, the complainant, that is the petitioners, did not appear before the hearing officer on the date of hearing as per hearing notice. So they chose not to appear. Number one. Number two, my lord, next paragraph. Learned advocate for OPs has submitted that at present issuance of completion certificate is not possible since the case is pending before the honorable court being number such and such. The complainant and the learned advocate have also admitted the same. The OPs have filed the copy of order. The challenge made to an order passed by the municipal building tribunal dismissing the appeal is founded on the legal point as to whether the special officer building was competent to entertain the dispute under section 401 of the Kolkata Municipal Corporation. So that is pending, my lord. And third,
This point has already been settled by the court on several matters. Why don't you get the matter heard and disposed of? How can, tell me one thing, if the issue is pending, how can the state commission proceed? It can never be. Whether there is an order for taking coercive step or not. Get it heard. I'll keep this matter pending.
I'm so grateful, my lord. I'm so grateful.
Please come.
My lord, they have kept this intentionally pending, lordship.
Again, you are pointing out fingers to them.
I absolutely.
See what steps you are taking prior to pointing fingers on others.
Lordship, I shall do that.
The petitioner challenges the order passed by the State Consumer Disputes Redressal Forum. Step. It appears that the matter relates to issuance of a completion certificate by the Kolkata Municipal Corporation. Step. The said certificate cannot be issued allegedly because of pendency of a civil revision application before this court, being CO number 4034 of 2015. Step paragraph. It will be open for the petitioner to press for hearing of the said civil revision application. Step. The writ petition is made returnable on 14th of May 2025.
my lord, the other point, my lord, whether state forum's order can be challenged before this court or before the national.
Point of this writ petition.
Affidavit of service is taken on record. All points to be taken up next day.
Deeply
I'm
appreciated.
grateful. So this is my application.
In this matter, I am appearing
Recall, my
in
lord.
India. Before starting
This
my
related
matter
to-
starts, my lord, Lord, so please to direct the matter to file an affidavit. But I am only, my lord, seeking 1 week's time.
Again, 1 week's time.
No difficulty.
What is the connected application for?
But I'll tell my lord what had happened. My lord will recall, my lord, there was a show cause notice, my lord, issued on the basis of, my lord, alleged, my lord, preliminary investigation report, which was not served on us. My lord, we, my lord, have a document of compliance, which is required for, my lord, plying of vessels. We have, my lord, 3 ships, my lord, which go, my lord, from Calcutta to, my lord, Port Blair, carrying, my lord, essential items. When we filed the writ petition, my lord was pleased to, my lord, look at the matter, and my lord also directed that, my lord, no coercive steps to be taken by them. And the document of compliance, my lord, is valid from 2019, 2020 to, my lord, up to, my lord, 25th March 2025. Now, my lord, we wrote to them, my lord. Now, document of compliance, my lord, has to be renewed in the usual course. So we wrote to them, and my lord, quite naturally, my lord, there's also a my lord, order which says no coercive steps by my lord. Now, to circumvent that, they say because it is pending, we will not consider your application. Because, my lord, we continued to write to them. Kindly, my lord, look at my application and, my lord, my continued writing to them. And then, my lord, their response, which just came, my lord, after, my lord, we have served, my lord, this application.
Yesterday evening it was served.
My lord, kindly
Yesterday
look at,
evening.
my lord, this is, my lord,
Well,
what they came
tomorrow,
up
well,
with.
just few, my lord,
May I just,
half an hour.
may I just show, my lord, the documents? My lord, kindly look at, my lord, page 147. Sorry, my lord. First, my lord, may I show the document of compliance, which is at page 41.
Where is your application for renewal?
My lord, that is, my lord, at page 147. (147) at 145. That's the, my lord.
145 is
147
147
is, my lord, a covering letter.
is the covering letter.
And my lord, 148, my lord, is the application.
This has not been considered.
And no, my lord, and very important, not considered. And my lord, we go on, my lord, writing letters to them, which my lord will find at, my lord, pages 196, 199, and 203. Give me the second volume. Where's the second one? Second volume. My lord, 196, my lord, will find.
Yes, 196, 203.
My lord, at the top, my lord, 6 March 2025.
Right. Renewal.
Then, my lord, 197, my lord, is the letter itself, 6 March. Then, my lord, will find 199.
Why is your client not?
And, my lord, just may I show the order, my lord, once, my lord, my lord's order. If my lord specifically said no coercive, it doesn't mean, my lord, they will now, my lord.
No, but then why is it not being considered?
My lord, it was not considered because of the fact that safety measures are there. Now, my lord, because
Let
of
them
pendency
know
of-
that these are the safety measures that they are supposed
you-
to comply with. Let them do it.
auditor has to be appointed.
Well, it is to be done by you.
My lord, DGS.
Whoever it is your part
My
and you have to
but
do it.
Until and until safety measures, my lord, is not considered by your lordship.
Is the court here to consider the safety measures or is it for your client to consider it? Take a decision on the application filed for renewal.
Kindly look at, my lord, 111, my lord's order. Because, my lord, the expiry is, my lord, as of today. My ships immediately will stop, my lord. I give essential supplies, my lord, to Port Blair. And my lord's order protected us.
2017, lost one person lost his life.
Oh,
My lord,
for-
2024,
All that was-
3%.
let them,
My lord,
you
as
let
you-
them know that these are the steps you are to comply. If they comply, fine. If they do not, they do not. Cancel it. Do whatever you feel
you
like. You cannot sit tight
As
like
you-
this.
as you-
My lord, may I show, my lord, 111, which is my lord's order? 111.
It's 19th of February or is it?
My lord, 13th February is the first order.
13th.
I have it over here.
Yes, my lord. I'm so grateful, my lord. Kindly see, my lord. 10. And no affidavit has also been filed, my lord, in the main matter.
Please come.
My lord, kindly see, look at, my lord, paragraph 6, second page. The
Yes.
petition has contained there's a valid document of compliance in respect of the ships issued on 1st June 2020, same it validated 25th March 2025, which is, my lord, as of today. Now, my lord, kindly look at 10. Respondent authority is directed to forward a copy of the preliminary inquiry report conducted by Director General. As such, instructions shall be forwarded as to whether the conducted upon prior notice. Matter stands adjourned. Then, my lord, respondents are restrained. Paragraph 12. Restrained from taking any coercive steps against the ships of the petitioners till 25th or until further order, whichever is earlier. Then, my lord, was pleased, my lord, to extend that order till, my lord, 30th April. So this order subsists. My lord, next.
Why are you taking so long for filing the opposition?
My lord, last 2 days back, my lord, I have handed over.
Handed over what?
Handed over, my lord, a reply and my lord, paragraph is reply. That is my lord, last 2 weeks, 2, 3
Then
days back.
your client is responsible for the delay. Why will the petitioner
So, Lord,
suffer for
kindly,
it?
1 week's time, I am praying for from my lord, at the time of my lord, submission. Before
For 1 week, you may prepare your opposition. No difficulty. Why will the application not be considered from February?
my lord, your lordships kindly send this matter back to my lord, DGS. My lord, he will consider this. DGS
And then what will the petitioner do? Today is the last date of the validity of the certificate.
They should not, my lord, interfere, my lord, with my functioning. My lord, that's my lord's order. No coercive steps. And, my lord, kindly look at, my lord, this reply I've handed over. This is what they say. Because otherwise, my lord, essential supplies, my lord, will stop.
They can ply the vacant one to the other technical managers.
Huh?
Technical.
I didn't get it.
How can it's the DOC is in my name,
Lordships kindly relegate the matter to my lord DJs, he will consider.
and in the meantime, my lord, then no further, my lord, and my lord, I have, my lord, letters, my lord, from other, my lord, stakeholders, my lord, addressed to us saying that you can't stop supply. My lord, kindly look at, my lord, this, my lord, letters, my lord, given, my lord, to the Director General of Police, Director General of Shipping, my lord, by, my lord, the government saying that you can't stop this essential supplies to Port Blair. And my lord, the trade association where, my lord, the supplies go. My lord, kindly protect that part of, my lord, the order.
Writ petition was filed by the petitioners challenging a show cause notice dated 3rd January 2025. Stop. The matter was heard by the court on 13th of February 2025, wherein the court took note of the fact that there is a valid document of compliance in respect of the ships issued on 1st June 2020, valid till 25th March 2025. Stop. The respondents were restrained from taking any coercive steps against the ships of the petitioners till 21st February 2025. Stop. The interim order passed by the court was thereafter extended on 19th February 2025, and the same is valid till 30th April 2025 or until further order, whichever is earlier. Stop. Paragraph. In the meantime, an application was filed by the petitioner seeking renewal of the DOC audit. Stop. No decision has been taken on the said application for renewal. Stop. The petitioner will not be in a position to ply the ship as the document of compliance is valid till today. Stop. Paragraph. It has been submitted that the petitioner supplies goods from Kolkata to Port Blair, and if the ships are not permitted to ply, then the residents of Port Blair will not be able to receive the essential articles. Stop. Prayer has been made to permit the petitioners to ply the ships. Stop. Paragraph. It appears that direction was passed upon the respondent authority for filing affidavit in opposition way back in February 2025. The same has not been filed till date. Stop. Neither has the application for renewal of the document of compliance been disposed of by the authority. Stop. Considering the fact that the petitioner supplies essential articles to Port Blair, the respondent authority is directed to permit the petitioner to ply the ships pending consideration of the application for renewal of the document of compliance. till 11th April 2025 or until further order, whichever is earlier. Stop. The Director General of Shipping is directed to take steps for consideration of the application made by the petitioner seeking renewal of the document of compliance in accordance with law at the earliest, but positively prior to 9th April 2025. Time to file the affidavit in opposition by the respondents is extended till how soon?
Till next
8th of April, 8th of April 2025.
I will be present.
What is this for?
Well, that's the response to that. Well, that may not be. Well, it shows because it's pending. Well, they say we are not going to consider. Now, it is taken care of. That issue.
Yes.
Well, and then makes it since the order is 11th, makes it returnable on the 9th or the 10th.
They have been permitted to file their affidavit within
8th April.
8 तारीख बोलना तो
And they have to consider by 9th, so kindly put it on the 10th.
all right, 10th of April.
That's right.
And
No, ওটা 8 তারিখে থাকবে returnable on. Yes.
This
Yes.
is my prayer, if it's possible, kindly extend the interim order till, because if there's any slip, then immediately the vessels will.
30th of April, the interim order is there.
Yes, till 30th of April. This order till 30th of April. That's why I was praying.
13th order is 9th.
No, 30th of the no coercive steps. The earlier order is still 30th April.
Earlier order is still 30th, no coercive steps.
Yes, now has said that not to stop me from
No,
flying.
they will, yes,
So
till
kindly
11th.
make it coextensive with 30th April.
I am not, because I want to keep it pending for taken up for
Very well.
consideration prior to that. Let us see what comes up, because
Very well.
safety issues are involved.
No, the safety management certificate, which are there all valid till 26, 27, and 28.
Then what is the
I
document
don't know.
of
This document of compliance, they only have to audit and see the safety management certificate and give it.
Let us come back.
Then
to
the-
Page 150, we'll find the safety management certificates for the 3 vessels are all valid till 26, 27, and 28. I checked that. I checked on that.
Yes, next.
This is the affidavit of service.
Yes, yes, affidavit of service taken on record.
I'm grateful.
Application disposed of.
No.
No, application is
That's-
pending.
Yes.
Because the renewal is pending.
Yes.
This application, I have to file again.
No.
Main writ petition.
Main writ petition.
As you
Application is only for renewal.
Grateful.
Sorry.
Look,
Lordship, I am
retain
referring on
its
behalf of
position.
the
I'm sorry.
Yes.
Retain its position.
Yes, yes.
I'm so grateful.
Lordship, regarding item number 11 on behalf of the respondents, your Lordship. As per your Lordship direction, report has been filed.
Lord, this report had to be, Lord, given to us on the 21st in terms of your Lordship's order dated 12th March 2025. Now,
Hmm.
Lord, it is just being handed over. Lord, I really don't know what is there in the report. That's all.
Was inspection conducted? Are you aware?
After this,
Lord,
Lordship, before
after the
report-
order, they have totally stopped, Lord, inspecting the goods. Lord, we have procured new Lord, raw materials.
Huh.
We had called them, Lord, for inspection. There are repeated letters. They have stopped, Lord, inspecting the goods.
Lordship, before
Lord, now, Lord, the question is, Lord, contractually, after we get the raw material, unless they inspect, we can't, Lord, put them into production. And Lord, then,
The
Lord,
raw materials are also required to be inspected.
there are 2 stages. Your Lordship's order, Lord, records. Your Lordship, kindly come to paragraph 4.
Hmm. And then but now inspection, yes, the first inspection
There are 2 stages, Lord. First, Lord, on procurement.
on procurement.
And Lord, they approve the procurement, and then, Lord, I
Put
put
it
it
to-
into production. And then, Lord, finished products,
They will again inspect.
and then, Lord, when we supply it, they will again go through the checks, Lord, for the purpose of ascertaining whether the goods are in accordance with, before the goods are made to use, Lord,
right.
these are.
Yes,
Lordship. before passing of this your lordship's direction, your lordship, the inspection has been made out on 20th September 2024, your lordship, and the found that the goods 35,250 numbers of the goods are rejected on such a date as per the inspection. And thereafter, your lordship, regarding this,
33.
lordship, no cause notice has been issued upon the
33.
writ petitioner on your lordship, on your lordship, 3rd October 2024, your lordship, and they have replied regarding this. And thereafter, your lordship, the answer of the writ petitioner is not satisfactory, as because the as per the parameters, the goods not found. And thereafter, your lordship, on 27th November 2024, your lordship again issued a letter to the writ petitioner, your lordship, regarding temporarily delisted the writ petitioner, which the facts, lordship, not submitted before your lordship. Only the filing writ application for taking advantage. Lordship, at this stage, the writ petition.
Has the fact of delisting the petitioner been communicated?
Yes, your lordship.
Lord, post delisting, they have done a scientific audit, and Lord, they have approved the materials. I have got the certificate also. This is
annexed with the writ petition.
It's not annexed. This is subsidy.
The delisting was prior to this.
Lordship, in my report, your lordship, kindly
not one of these contractual obligations on which the writ petition is filed. My learned friend is talking about some other contract, which is
some other contract.
No, your lordship, kindly see, your lordship. I have submitted in my report, your lordship.
This is the
Let
problem.
them go through the report. Please come. A report in the form of affidavit filed by the respondents in court today is taken on record. Stop. Copy of the same handed over to the petitioner in court. Stop. It will be open for the now opener आगे लिखूं जे learned advocate for the respondent submits that the petitioners have been delisted.
Lordship.
In respect of all the contracts. What is my learned friend saying? There are seven contracts.
Lordship, kindly come to paragraph number 3 of my this. Like annexure B, your lordship.
What is my
considering the non-conforming of the product to be
page.
Lordship, in annexure B, your lordship, I have not paid. Sorry, not. I have
paginated.
Not paginated.
Kindly come to annexure B, my learned friend's letter on which my learned friend relies. Kindly, Lord, come to paragraph 4. You are advised to take necessary action as per clause such and such.
Before 4,
with effective date, inspection of materials against purchase orders placed before the temporary deletion of firm's name from the approved list of vendors will continue to be carried out as per extent policy norm. So, Lord, whatever goods they have already inspected, we are permitted to continue. And Lord, subsequently there is
the petitioner's form.
Only taking advantage for filing the writ petition.
Petitioner's firm has been temporarily delisted. From the approved list of vendors. And the delistment will be valid. Now, not valid, will be carried out as per the extant policy / norms. Stop. The order of delisting is appealable before the appellate authority within a period of 60 days from the date of communication of the said order. No appeal has been filed.
Lord, this does not relate to the contracts on which writ petition has been filed.
No appeal has been filed therefrom.
On the contrary, on
according to the authority, there is no scope for further inspection.
Lord.
This is your stand.
No, no, further inspection.
My right, as I'm standing on the 27th January 2025 letter, your lordship, and they have challenged this. No, he has no. You cannot inspect the same.
Right.
just made a stand.
Either his stand is that no inspection because of this particular letter,
And the
or my lord, his stand
temporarily-
is that
But
we must inspect
delisted.
in terms of the
So, your
25,
lordship,
2025.
regarding this, your lordship, writ petition is not maintainable, your lordship, as because when the
But can I, my lord,
I-
have
Yes,
5 minutes of uninterrupted?
It will be open for the petitioner to file exception to the report filed in court today. Within 1 week will be all right with you?
Perfect.
আজকে হচ্ছে 25 1st 2nd April. Released on 8th April.
Lord, Lord, let them, Lord, inspect the materials in the meantime. They are
They say they have already inspected and delisted you. Found to be.
delisted in respect of a contract which is not the subject matter of the writ petition.
I
Your
don't know.
lordship will kindly take
I do not know. He denies.
page 6, Lord, kindly page 6. Lord, this is, Lord, kindly, Lord, see the document. Lord, it talks about a particular contract. That is not the subject matter of this writ petition, because, Lord, if they have delisted me, why should I ask for inspection of the materials of those materials?
This is what he is also
But
submitting.
this is what I am saying, Lord. These 6 contracts, which are the subject matter of the writ petition, the lordships will kindly, Lord, have a look at this, Lord, and kindly see the contract. This is
Next
mentioned.
day.
Lord,
Please next
kindly,
day, 12.
Lord, consider, Lord, if they don't inspect, Lord, the entire goods are going to be stored, Lord. I can't, Lord, manufacture. There will be breach of contract. Your lordships may kindly, Lord, my learned friend says, Lord, he wants to inspect in terms of the new guideline.
nothing new guidelines as per the contracts.
Lord, kindly hear me, Lord, for 5 minutes on my writ petition.
On the
Lord,
next day.
As per the
I
subsidiary
didn't
On the
have a
next day,
chance to
it
place
cannot
my
be
case.
assistant, your lord.
Yes.
Lord.
Item 12.
I am appearing on behalf of the state.
Yes.
Lord, this is, Lord, absolute, Lord, what should I say, Lord? They don't give the report, they don't, Lord, supply the report, they don't give us a chance to look into the report and come and say something, Lord, contrary to the records. Lord, your lordships will kindly keep it in mind, Lord, when we come back with the exception.
Yes. Yes. Yes.
My lord, this is a matter, my lord, in connection with the Shiptanabad Imambara, which, my lord, flows from the King's Endowment Act of 1911, which, my lord, I have mentioned on a prior occasion that the district magistrate is the custodian of the Imambara in terms of the act. Now, my lord, the holy month of Ramzan is going on. The Imambara doors, ingress and egress, has been, my lord, obstructed. We have, my lord, placed an representation before the district magistrate.
Which
We
page is
only
it?
want, my lord, it is, I'll take your lordship to, my lord, page 90. There are other also, my lord, at 6 is district magistrate
Yes.
South
So
24.
far, my instruction, both the police station has taken the
Taken
possible
steps.
step, my lord, and FIR has been already been lodged.
But will you stop only by lodging the FIR? Thereafter, what steps are you taking?
Now, my lord, the investigation of the case is on progress. My lord, kindly see the report from the Metia Buruj police station, my lord, kindly see. A specific case was registered by Metia Buruj police station dated 13th March 2025 under section 285 BNS 2023 against the respondent number 5 and 7, that is private respondent. FIR and formal FIR are.
Do you have any report from the DM?
No, not
Please
from
come.
the.
Are you appearing?
No, I am appearing for the private respondent. My lord.
Are you the obstructors?
Not my lord, your lordship would kindly consider one aspect. My lord, the main doors of the Imambara, my lord, the egress is left free open. Only, my lord, the temporary
Stalls.
stall has been made for selling of skull caps during this month, my lord, the month of Ramadan. If your lordship says, my lord,
Why don't you shift it? Why don't you?
Take to, my lord, vacate by Monday, my lord, when the month is ending.
My lord,
After the Ramzan month is over and after the religious occasion is over, you will remove. You will not be there after that.
I indicate, my lord, Imambara is not a place of worship, my lord, as has been indicated by my lord.
Very well.
My lord, your lordship, my lord.
What right do you have to block the ingress and egress?
I have not blocked. Your lordship would kindly see I am carrying.
Please come.
Your lordship would kindly see the photographs once, my lord. The egress and ingress are all open.
देखिए.
My lord, the main doors, my lord, which has egress and ingress, my lord, is open.
My lord, that's the picture taken of the gate.
Extreme front of
But
the-
my lord, I have annexed.
And manager of the Imambara has stated no permission has been given to them.
My lord,
That is the reason he says that he'll move out after the festival
Lordship, my
is
lord, since
over.
a picture has been placed from the wall, lordship will take into consideration that picture. It's only of the gate. It doesn't take into consideration the obstructions.
For your lordship would kindly, my lord, appreciate, my lord, the private.
Alikunto, the petitioner
Technicalities
complains
be
that
taken care of later on.
the district magistrate has not taken steps to consider the complaint lodged by the petitioner against the illegal blockage / obstruction of the egress and ingress of the Shiptanabad Imambara, within bracket Shahi Imambara, at P
3%.
34 Nawab Wajid Ali Shah Road, within bracket Garden Reach, Kolkata 700024.
And my lord, another thing, my lord, from the report of the Garden Reach, it appears the 3 persons were arrested. My lord, kindly see second
Acha.
page of the report.
It has been submitted that during the holy month of Ramzan, the place remains hugely crowded, and if the stalls are not removed, it will be difficult for the visitors to access the said place. Photograph of the frontage of the Imambara has been annexed to the writ petition. Paragraph. Learned advocate representing the state respondents has obtained instruction from the
Both the police station, my lord, Garden Reach, as well as my lord, from the
Media Buruj, officer in charge Garden Reach Police Station and officer in charge Media Buruj Police Station. It appears that a criminal case was registered Vide Media Buruj PS case number 43, dated 13th March 2025, under section 285 BNS. The report of the Garden Reach Police Station mentions that.
Well, second page, kindly see that as such 3 persons were arrested on 12th
3
March.
persons were arrested on 12th March 2025 and prosecuted under section 40, space Roman 2, space 66. Calcutta Police Suburban Act. And the same has been diarized via Vide Garden Reach PS GDE number 885, dated 12th March 2025. Watch is been maintained so that no obstruction is made at the entrance of the Imambara. It has been learned from the manager of the Imambara that no permission has been granted to any person for installation of temporary stalls in front of the main gate. It has further been mentioned in the report that one of the arrested persons happens to be the staff of the Imambara. Paragraph. Learned advocate representing the private respondent submits that they are not obstructing the entrance of the Imambara. Stop. Temporary stalls have been set up for selling skull caps during the holy month of Ramzan. Paragraph. Learned advocate undertakes that immediately on the end of the holy month, comma, these stalls will be removed. Paragraph. Upon hearing the parties and on perusal of the materials placed before this court, it appears that admittedly temporary stalls have been set up without any permission. Stop. Paragraph. The district magistrate is directed to ensure that the egress and ingress of the entrance of the Imambara remains obstruction free and the visitors do not face any problem while accessing the holy site. Stop. Necessary steps in accordance with law shall be taken by the district magistrate in the event any contravention is detected. Writ petition stands disposed of.
Grateful.
Time for the petition.
Not object to the respondent Punjab National Bank.
Yes.
Now, let the petitioner is running a rice mill. Now,
Who are you representing?
Punjab National Bank.
bank.
Punjab
Respondent
National
and
Bank. There is a private respondent, I see.
Those are the pro forma respondents.
Reserve Bank is also there.
Who are the guarantor? Who are the guarantor of the loan? What happened, Malad? In 2022, Malad, the central government, Malad, initiated a scheme to grant a loan, which is called, Malad, GECL, which is Guarantee Emergency Credit Line Loan. And in terms of this loan, Malad, first 2 years, I have to pay the interest, and remaining 3 years, I have to pay the principal. Now, Malad, in terms of, Malad, the petitioner also holding 2 current account. Now, Malad, Malad, cash credit account, Malad, 2 cash credit account, and Malad, 1 this GACL account. Now, if your lordship kindly come to page 27.
What steps have the bank taken?
Now, Malad, what happened in spite of payment, Malad, regular payment? Malad, and Malad, in spite of Malad, there is a Malad sufficient amount lying in my account. The bank, Malad, they are saying, Malad, I must say, Malad, they are saying that they are not regularized my, Malad, which is at page 67. They are saying that they are not regularized my overdue, Malad, in GACL account. But if your lordship kindly come,
I can see a 13-2 notice issued.
yes,
Thereafter.
thereafter. Now, Malad, kindly come to page 41 once. Page 41.
Tell me what happened.
Now, Malad, all of a sudden, Malad, in spite of regular payment, Malad, the bank, Malad, on 4th of March 2025, recall my Malad cash credit account. Malad, they are saying that there is a Malad no valid factory license. Though I have applied for factory license long back, and I have handed over this copy to them.
Making an application and having a license are 2 different things.
Malad, I have made an application.
What are you using the money for? If you do not have a factory, how are you running the factory?
Malad, I have a factory. Malad, I have applied for Malad. Neither my.
Are you running without a license? You cannot run.
Malad,
Line closed, my lord. Factory line closed.
It's running, Malad, and Malad, I have.
How can you run without the license?
Malad, I have applied for Malad in process.
Your application does not give you permission to run.
Malad.
They have not.
Does that mean that you have a permission to run?
That is altogether. It's the factories are without factory license. I can take steps for renewal of the factory. But my question is that when I am paying regularly to the bank, and
See, the bank is supposed to see whether the money that is being given to you is utilized in the proper manner or not. They see that your factory is closed and you say you are taking the money.
Kindly see page 41 once.
No, nothing doing.
Kindly see page 41 once.
I'll not see anything.
They on 1st of March 2025, they are regularizing my account on 1st March, and now they are saying they have recalled my account in 28th of February. And now what happened on 13th of March, they issued 13-2 notice declaring my account NPA, which is against the regulation of the Reserve Bank. Lordship, kindly appreciate. Until and unless this, and for 90 days, if
for which alternative remedy is
no, that is a different. That is different. That is a different. But in spite of
13-2 notice cannot be challenged.
I have not challenged. I have not challenged 13-2 notice.
Right.
I am challenging the recall notice. And so far as declaring my account.
Where is the recall notice?
Recall notice is at page 52. Before, kindly consider two account statement. It is not a case that I am defaulted in making payment. They are saying that they are not regularizing my account, but on 1st of March, the account says that they are regularized my account. It is not a case that my account doesn't have the money, and there is an auto debit option.
That account is also inoperative for want of renewal, my lord, for a long time.
They are saying that they have not renewed, but I can show on 1st of March, they have renewed the account. My account statement is there.
Page 52, what do you want to show?
This is the recall notice.
Yes.
This is the recall notice. And I have given reply at page 64. Page 52 is a simple recall notice. Page 64, I have given the reply. Now, if
you have recalled the payment due with a notice dated such and such, no steps have been taken by you to set right the irregularities. Unable to permit you to invoke the guarantee and call upon you to pay the aforesaid amount. Yes.
Now, kindly come to page 64. What I have said, that my account, and I have annexed the bank statement. It is not a case that I can show for each and every month. The installment has been deducted from my account. Each and every month till the month of March.
Page 64 is what?
My representation against the recall notice.
Yes.
Where I have specifically said that from 2007, this loan account is there. কিন্তু বর্তমানে উক্ত অ্যাকাউন্টটি আপনারা কোনো কারণ ছাড়া এনপিএ করলেন, কারণ উক্ত অ্যাকাউন্টটিতে আমার টাকা থাকা সত্ত্বেও আপনারা টাকা অ্যাকাউন্ট থেকে আমার লোন অ্যাকাউন্টে অ্যাডজাস্ট না করে এনপিএ করলেন, যা আমার কাছে হতাশাজনক. I can understand that I am defaulted in making payment.
Admission.
But there is no such default. And kindly see now page 67. Lordship considered the recall notice.
Yes.
But they have said that I am unable to make payment. Now see the 67.
They have not said you are unable to make payment. They have told you to make good the irregularities.
That I have deposited.
You have been directed to set right the irregularities, which you have failed to do.
I have deposited. I have deposited.
It is their undertaking. A letter was given to bank by the petitioner.
Take the chance.
That's short.
Yes.
To make payment.
Kindly consider page 33. I have given all the documents, including that I made an application for renewal under the factory license.
What is your submission?
First submission.
Only one point. Only one point. My lord, before declaring an account NPA, my lord, there is a Reserve Bank guideline. Lordship, kindly see that my account remain inoperative for 90 days. Now, Lordship, this is 2.2 point. My lord, that this is C, clarification regarding definition of out of order. My lord. From my account, I can show your lordship that on 1st of March, this account is remain operative. The transaction was there. একটা দিয়েছিস আচ্ছা মোটাটা পেজ নাম্বার বল
Yes.
So lordship, find out that 90 days, the account should have been inoperative for 90 days. This is the guideline of the Reserve Bank, my lord. The outstanding balance in the CCOD account remained continuously in excess of sanction limit drawing power for 90 days. The outstanding balance in CCOD account is less than the sanction limit drawing power, but there are no credit continuously for 90 days. Or the outstanding balance in the CCOD account is less than the sanction limit drawing power, but credits are not enough to cover the interest debited during the previous 90 days period. The definition of out of order as at paragraph 2.2.1 above shall be applicable to all loan products being offered as an overdraft facility, including those not meant for business purpose and for which entail interest repayment as the only credits. Now, this is the master circular of the Reserve Bank, which is quoted in the document what I have handed over to my lord. So, if your lordship kindly consider the bank statement.
Tell me what are the irregularities?
My lord, first of all, the factory license was not given. The breach of sanction, and the factory is lying closed for a long time.
Was the cash credit account meant for this?
Cash credit was for this factory.
For this factory?
Yes.
All right.
And moreover, the contention with regard to fund lying in the cash credit account, with regard to auto debit system, that account is inoperative. Bank cannot
from the account to which the cash credit account money will flow is frozen.
This cash credit account is lying inoperative due to want of renewal for a long time. Since they have failed to comply with certain things, which was
what
required.
Are the certain things? You file a report.
And my lord, in reply to my learned friend submission, lordship kindly consider paragraph page 57, paragraph 3. It is their contention that in 2024-25, 1 crore 15 lakhs rupees routed from this account. If I put a question to myself, if the factory remain closed, my lord, how this amount routed to this account? It is their admission, my lord.
How can you run the factory without the license?
My lord, I have applied. That is that is
factory is closed, my lord, for a long time. From inspection report, my lordship would see.
My lord, kindly see, it is their admission, page 67, paragraph 3.
Pradeep, the recall notice of the.
They are not challenging the recall notice. In fact, my lord, they are challenging the 13-2 notice. My lord, on the date of issuance of 13-2, my lord, the account has become NPA on 1st March 2025. For which, my lord, alternative remedy.
Prayer is not there for the recall notice?
Prayer is there, my lord.
Is there?
Yes.
For recall notice only, my lord. For recall notice, I prayed for, my lord.
The recall notice of the cash credit account dated 4th March 2025.
Indirectly, they are challenging my SARFAESI action, for which alternative remedy is there.
Is impugned in the instant writ petition. Stub paragraph. On a perusal of the impugned notice, it appears that the petitioners did not take steps to rectify the irregularities in the subject account.
This is the letter where they were demanded.
Stop. Next. Learned advocate representing the bank submits that the factory in respect of which the cash credit account was opened is lying closed for a considerable period of time. Stop. The petitioner does not have the license to run the factory. Stop. There are outstanding dues and proceedings under the SURFACE Act has been initiated. Stop paragraph. The bank is directed to file a report by way of affidavit disclosing all facts and figures by 8th of April. Reply, if any, by 17th April, released on 22nd April.
Meanwhile, no coercive step. My lordship, if they are proceed with 13-4, my lord,
They will
the
proceed.
writ
That
petition,
is
my lord, become infructuous, my lord.
nothing doing, sir. If the writ petition becomes infructuous, another avenue will be open to you. Next.
I'm for the petition.
I'm for the
Your
respondent
ladyship
number
would
8.
remember,
Respondent number 8, my lord.
your ladyship would remember
Who is
that
the respondent number 8?
The daughter-in-law.
daughter-in-law.
Your lordship would remember that
This is a
Daughter-in-law.
matter where the mother-in-law was forcefully ousted from her own premises. And subsequent to that, my lord, on your
the
lord's
state
order
was supposed
dated,
to file a report.
yes, the state was supposed to file one report. And subsequent to your ladyship's order dated 11th March, I
Has
had
it
tried,
been acted upon?
no, my lord, that's where I'm coming to. I tried to enter my premises on 15th of March, my lord.
They are very
Thereafter, I
much
went.
Please wait.
I went to my own premises on 15th of March. I was restrained.
By
I was
the-
not allowed. I was restrained by the respondent number 8 and her mother, my lord. Surprisingly, which I did not know that she was also residing in that
there.
premises. Now, my lord, I came to the police station and subsequently, it's also a matter of fact, my client gave me a call. Being the advocate, I also went to the police station. I lodged a complaint there that I had been restrained. And after that, Sub-Inspector of Police, one Dipankar Banerjee, with his help, he wore a body camera and he, along with the petitioner, went to the premises to safely reinstate in her property. After that, my lord, she could enter into the premises. After entering into the premises, she found out that her daughter-in-law's mother and father, they were also residing in that particular premises. My lord, I could not even stay there for even 24 hours. I entered there on 15th of March. Thereafter, I had mailed the police station that I could enter here, yet I was restrained more than for 30 minutes for 1 hour. Primarily for that time period, I was not entered. I was not allowed to enter there. And I was vigorously threatened about being implicated on false and frivolous cases, my lord. Each and every hour, my lord would see that I have annexed in my Can 1 application. I have mailed the police station about the ongoing incidents that were going on in that particular house. Suddenly on 18th of March, and my lord, I will come there later. On 16th of March, I was not able to sleep. I was not given access to the kitchen, please, not even the water supply.
How
Not
many kitchen are there? One.
One, my lord.
One kitchen.
Yes, my lord. One kitchen is there. Thereafter, on 16th of March, I was physically assaulted by the mother and father of the daughter-in-law. And my lord, she purposefully instigated my granddaughter, my grandson, to poke me, to instigate me to do something wrongful. And yet I came to know later that one FIR was also lodged against me by giving the instance of my grandson. My lord, on 16th of March, I had to go to the police station. Before that, I had gone to the hospital to give one medical. I was physically assaulted because calling to the police station, I asked for help. I sought help of the police officials to come to my home and give me some help, because the peace and tranquility should have been maintained at that point of time. And when I went to the hospital and returned to my house, the doctor said that I need rest there. My blood pressure was increasing. I was abused. I was heard abusive languages. And I was pressed against the wall, my lord. Thereafter, I went to the hospital. After returning from the hospital, I was not allowed to enter into that premises again. I went to the police station. I have lodged the complaint, and till the date, I am not able to enter into that premises again, my lord.
All right. Yes.
My lord, they are very much inside the premises, my lord.
Means?
My lord, the mother-in-law, my lord. That's the instructor.
Why is your mother over there? Why is your mother and father over there?
Because, my lord, I have a child, my lord, who is only 7 years old.
So what?
And, my lord, I stay there alone, my lord. And there are threats by the mother-in-law, by my husband. Each and every day, some or the other person comes inside the premises. I fear, my lord, to open the gate lock, my lord. And now, my lord, I have, when the fact that on the very date.
What do you do?
But I'm a homemaker.
All right.
My lord,
So you stay at home,
my
right?
lord, my lord,
If your mother-in-law stays over there, where is the difficulty?
my lord, on the earlier occasion also, I had said that, my
There
lord,
is no difficulty.
no difficulty. That is why your lordship had given that relief to the petitioner, my lord.
Right. Let the mother-in-law remain and your mother and father should go back to their own house. Do not let your parents interfere in your matrimonial issues.
My lord, I'm deeply obliged. My lord,
Tell
I
them to
bow
go.
down to
Let
that,
the
my lord.
mother-in-law come.
Yes, my lord.
Let your mother and father should go and the mother-in-law should be here.
My lord, if I may say, my lord, I had lodged an FIR, my lord, when I was wrongfully restrained in my matrimonial house, my lord. On the very day when my mother-in-law came, my lord, with police assistance, my lord. On that very day, my lord, after few hours, my lord, me and my child, we were locked inside one room, my lord. We were not allowed to come outside my own matrimonial house, my lord. Thereafter, my lord, I had lodged an FIR against the
Did
mother-in-law
you
on the very
approach
day.
the regular forum regarding matrimonial disputes and everything?
Lot of 498A cases
That is
pending, a
different.
domestic violence cases pending.
Did you
again.
get any obtain any order for
But it is
residence?
pending, my lord. It is pending.
There
They
is
are
no order
they are
for
not filing
residence.
any affidavit of assets and liabilities
So
over
what?
there. My lord, that
You
is why
file.
the case is not proceeding, my lord. My lord kindly appreciates, my lord. I am a lady, my lord, having a 7-year-old child, my lord.
She is also a lady.
My lord, I deeply, I bow down, my lord. I bow down, my lord. But kindly also understands my difficulty, my lord. I got married thinking that I would have a happy married life, my lord. Thereafter, my lord, my mother-in-law is torturing, and my lord, such allegations against her own grandson, that I have instigated my own son against my mother-in-law, my lord. Such allegations, my lord, these are very new, my lord. And my lord, a 41A notice has been served to them, where, my lord, the police had given them the choice to come back at a suitable date when it's convenient to them, my lord. They have not replied to that 41A
It
notice.
is for them.
Yes,
Whether they reply or not, the law is there, law will take its own course. But
Deeply
why
obliged.
will you not permit this lady? Where will this lady go and stay?
My lord kindly appreciates the allegations, my lord. She came she entered the subject premises on 15th of March.
I will listen to all your allegations, all your complaints, all your grievances once you let your mother and your father go out of that house. Your parents will not be permitted.
I have not created any obstruction.
May not be. You tell your parents to leave immediately.
Not first, my lord.
No first and second. Your parents have no right to stay in your matrimonial house.
Gives me only one day, my lord. Let me come back with instructions.
No instruction. What instruction will you bring?
My lord, because, my lord, my instructions were, my lord, it's only me and my son who are living, living, my lord. It's not my mother-in-law who are living.
My lord, let the police report be filed. It is
Very
also
well.
reflected there.
Gives me one day.
Very well. I will restrain your mother and your father, your parents, to enter that house.
I'm obliged, my lord.
Because you say your parents are not staying over there, so I'll restrain them. And then if they are found over there, the police will go and send them out. All right.
But, my lord,
no question. You said just now.
No, my lord, my lord, I was only praying that let me come back with instructions, because my instruction is that.
No, your instruction is they are not staying. Let them not stay. If they are there, they'll be thrown out. It's as easy as this. Who is for the state?
Lady appearing for the state.
Where is?
19 Kundam or 19 my own lake.
Get the report from him. Where is the report? You have it over here?
No, my lord.
Get the report. Immediately get the report from him. Have you followed? I'm passing it over for the time being. Get the report.
I'm obliged, my lady.
Call the next matter, please. Yes.
The last occasion it was adjourned, my lord.
Because the respondents were not there.
Yes, my
Today are all the
She is
respondents.
also appearing for PCB. She was there on the last occasion.
But then she did not have instruction.
But I did not have
The
instructions.
intimation that she was appearing for
Yes.
PCB.
Yes, well.
So therefore, my lord, everyone is there. Diga Champur.
Yes.
PSD.
Raise your voice.
My lord,
Yes.
this is, my lord, I am challenging an order. Lordship may first, for a glimpse, first comes to the ordering part and thereafter I'll take your lordship to the other parts, my lord. Page 131, first volume, last paragraph. And thereafter I'll draw your lordship's kind attention. This
This
is in
order is
respect of
passed by?
the National Green Tribunal.
All right. Kolkata bench.
Yes, yes, yes. We therefore dispose of this original
There
application.
is an appellate forum.
Appellate forum, yes, it is there, but because of the Supreme Court judgment in Madras High Court, Madras Bar Association, it has been reiterated following that L. Chandra Kumar principle that,
L. Chandra Kumar says division bench.
and yes, we went to division bench. There is an order of this honorable court which says that it will be in single
the
bench.
single bench.
Single bench. And it should be in the single bench because 226.
Yes.
Everything done.
Just see, you go to tribunal, then go to the division bench, then come to the single bench, again go to the division bench, and then go up to the Supreme
Yes,
Court.
yes. That is the, my lord, scheme of the act, my lord, and the constitution. We therefore dispose of this original application with a direction the respondent number 1 to ensure that all construction which have been made in CRZ 1A as referred in the preceding paragraphs and the prohibition area and such are removed completely and the area is restored to its original form. Let such exercise be carried out within 3 months.
Date of the order, 21st of January.
Yes, yes. Now, my lord, kindly sees the tender. What happened is that, my lord, the CRZ regulations first came into, my lord, came into the picture in 1991. My lordship, may kindly, not, my lord, may I just make my submissions. Thereafter, in 2011, CRZ notification came by which, my lord, the 1991 notification was superseded and 2011 notifications were made in place. On the basis of that, a map was supposed to be drawn where indicating the lines of CRZ. Now in 2019, another notification came, that is in 18 January 2019, another notification came which says that minor tourism things can be done in respect of, may I just indicate the word, temporary tourism facilities shall be permissible in beaches which shall only include shacks, toilets or washroom, change rooms, shower panels, walkways constructing using such and such interlocking paver blocks, etc., drinking water facilities, seating arrangements, etc. And as such facilities shall, however, be permitted only subject to the tourism plan featured in the approved CRZ MP, which is not there in 2019. I'll show. As per this notification, framed with the due consultative process or the public approval hearing, which has also not been done, etc. And further, I can give the copy of the 2019. I'll draw your lordship's kind attention to everything. And further, subject to environment safeguards enlisted in CRZ MP, however, a minimum distance of 10 meters from the high tide line shall be maintained for setting up such facilities. Now, seeing this, the Digha Shankarpur Development Authority floated a tender which is at page 40 of the volume 1. Kindly comes to page 40. I'll be very short, my lord. I know, my lord. Page 40.
Yes.
Yes, Digha. Now here I should also say that there was existing toilet complex, which will also come from the other reports also. Wasteland, just. Digha Shankarpur Development Authority and the Department of Urban Development, Government of West Bengal invites online EOI for licenseship of amenity center, toilet complex, parking facilities, organizing cultural programs and some amusement activities at Dheusagar under DSDA as described in the schedule below from the intending persons organizations for specific purpose as stated there. The schedule is at page 46. Kindly comes to page 46. The licensee shall have to run the amenity center, toilet complex, toy train, children park, boating, parking facilities, maintain and keep the beautified area neat and clean, organize cultural programs at Dheusagar on every Saturday and Sunday, and other special days. Cultural program at Dheusagar shall have to be organized at his / her own expenses and all these things. All artists have to be approved. Toy train. Well, this was the basic scope. Now kindly comes to the next page. I was given authority to collect toilets for using the fees for toilet Now kindly comes to page.
What is the
What
immediate
happened?
cause
What
of
has been?
action?
Yes, instant cause of action is that Mr. Dotto had filed this original application challenging three things. First is the Jagannath Dham, which is being constructed in Digha. Second is the Satyajit Ray Memorial Cafe, which is being constructed by the state government. And third is our park, which is being run by a private entity pursuant to my lord. Now, what happened kindly comes to the report of DSDA. That will be at page 226. What we have done. 226. This is the report of the DSDA. This is being forwarded from the executive officer to the special commissioner government of West Bengal for filing a report to the National Green Tribunal in this matter. Kindly comes to the next page. Issue number 2 is our issue. Issue acha kano? Acha, planned and scientific development of Digha being undertaken in accordance with land use development plan such and such. Moreover, for the preparation of long-term master plan for substantial development of Digha and important coastal belts under the DSDA. All activities under CRZ. Issue number 2. This includes everything, not only us. This includes me. Except the lavatory block, no concrete structure is there. All structures made of temporary basis and made of ceramic tiles, structural beam, glass, ABC, PVC material, corrugated sheets, woods, bamboo, etc. Only lavatory block is concrete proof structure. A temporary structure over the roof of toilet complex is made of wood, corrugated sheets, etc. Next is, my lord, kindly comes to next page. This continues, my lord. Issue 4 is all structures are made of temporary basis and made of ceramic tiles, structural such and such. Kindly comes to the next page. The pathway is made of ceramic tiles. B, it is not a resort. This is basically some stalls for promotion of local handicraft and office rooms surrounded by toilet. Upper portion is built of corrugated sheets and PVC materials and wood. These are temporary structures made of container, wood, corrugated sheets, and all are easily removable structures. Temporary structure is made of ABC, PVC material, corrugated sheets, same thing. E is purely temporary structure made of container, purely temporary structure made of corrugated sheets, ABC, no concrete roof is therefore only 2.5 brick wall is there at the foundation. Now, the tribunal had called for a report from a committee constituted by the tribunal on the basis of which the entire judgment and entire thing which has been done is based. Now kindly comes to that committee. It is at page 267. 267. This is the committee constituted by the tribunal and this is the basis of the order passed against us.
Who are the members of the committee?
It is apparent. The first paragraph, members of the committee, although a person who was supposed to be the member of the committee was not there in the committee, a person who was not supposed to be the member of the committee was there in the committee, but that would be technical points which I can take, but lordship may not be.
Not right now.
Yes, because it is the demolition order is against me. If I take up technical points, then your lordship would find that your lordship may be of the opinion that I am trying to, my lord, move away from the main issue.
The main issue.
So therefore, let us come.
This committee was formed before my.
Yes. 1 point, my lord. This committee was formed. The report was given all prior to my impleadment in the original application. I'll show from the record by which.
Right.
Now, my lord, construction of amusement park at Dheusagar.
No, 1 minute. Let us see the committee members.
Yes.
Senior Environment Officer. ADMLR. Senior Scientist and Consultant. All right.
Went to Digha and visited the sites in 21st August 2023. We were not parties. We were not called for also. Now, my lord, page number 22, 23. These are the page numbers of the, my lord, this is of the original application. It is written in the committee. Annexure 4 shows pictures of a resort in Dheusagar having rooms constructed over the existing toilet complex. So, toilet complex is existing, admitted by the committee. and shops within bracket permanent in nature by its vertical expansion. First floor of the said structure is made with wood and brick wall having corrugated sheet roof and found vacant during the visit. The ground floor is found to be used for commercial stalls at present. Rooms with attached toilets found on the first floor with amenities like AC and TV. Now kindly see CRZ status. From the status report prepared by IESWM, this status report doesn't form a part of the records in the original application, has never been given, or the tribunal has also not shown, has not seen. So this report is based on a undisclosed status report which is not there in record. By such, and it is found that the said construction lies with CRZ 2, seaward side of the existing road. Kindly now remembers the construction in CRZ 1A has been directed to be demolished, not CRZ 2. The ordering portion I have shown to your lordship, and a small portion of it also lies in CRZ 1A. Not specific what is the portion which is lying in CRZ 1A. So 2 points. First, without giving the copy of the CRZ status report. Second, it is also vague. Second is shows the construction of a peacock shaped ornamental boat. It is found to be made of container fiber reinforcement plastic FRP, which is temporary in nature. Structure is construction on concrete base. CRZ status report again that the whole structures lied in CRZ 2, so not directed to be demolished. Next is a which appears to be construction of temporary habitations of such and such complex area are found to be raised structures. So CRZ status report.
Which of these construction are yours?
Everything.
Oh, the entire thing is yours.
This till my lord, the pages. This A is mine. B deals with different things. A is mine.
Amusement park.
Yes, yes.
And this inspection was conducted without giving you any notice.
No, we were not parties at that relevant point of time, so no notice.
May not be parties, but when they go
No, admittedly, no notice. But this came to my lord subsequently my notice, so therefore I am bringing. Now, my second part is construction of temporary habitations. This is also in CRZ 2, which has not been directed to be demolished.
All right, then what?
Now, my lord, the second is also CRZ 2. Third, page 28, shows construction of commercial centers, buildings, fish spa. It is made up of corrugated streets with glass walls, such and such at the foundation. This is said to be the CRZ status report that the whole structures lies within CRZ 1A. So this entire thing has been directed to be demolished. Now kindly see permissibility of activity. As per paragraph 8.1 such and such of CRZ notification 2011, no new construction can be placed in CRZ 1 except says, and now kindly comes to last. So CRZ 1 I am not following. I am following according to them as per paragraph 1 such and such of notification 11, buildings shall be permitted only on the landward side. So therefore they are considering me as building. We have tried to, my lord, make this arguments before the tribunal that the building is not defined and building means presupposes RCC constructions. So they have proceeded to consider these structures as RCC constructions or buildings, let us put. So therefore, they have said that this is contrary to CRZ violations, as appears from this report. I don't have the CRZ status report. Now, on the basis of this...
You say 2011 notification has been superseded by 2019.
Yes.
Let me see the notification.
Reasoning is, yes, I'll show. A notification 2011 or 2019. Reasoning of the tribunal is that even if this has been superseded, the 2011 map has to be followed until 2019 map is prepared, which is okay. But the 2019 map is in the process of being prepared. That will also I'll show. But and the 2011 map, which is supposed to be in public domain, is not there in public domain, which
has
was all
been prepared.
2011. No one has said.
No one has seen.
No. Because this was the submission made in the Mandarmani matter before your lordship, where one Article 12 authority said that the 2011 map is not available. I made, on the basis of that submission, I also made submissions before the National Green Tribunal that, look, this was the submission And this was a submission of an Article 12 authority that the maps are not available. I am also making that submission. The tribunal said that no, it is there in the public domain. You go find it out, but it is there. I'll proceed on the basis of that. So that is the contention. Now kindly comes to the lordship is there in 2019 notification.
Yes.
Yes, 2019 notification kindly sees now they are in exercise. Lordship is there. Now, therefore, in exercise of powers, this is no page.
Yes, yes.
Conferred on such and such, and in supersession of the coastal regulation zone notification 2011, dated 6 January 2011, express and such and such. So, subsequently, so therefore, this is in supersession. Tribunal has given the reason that even if it is in supersession, the 2011 map is there, so you have to follow the 2011 map.
Are the zones specified?
Yes, it is specified. I will be
The zones may have been specified in relation to the map. Has the zones been specified? The map
No,
and
because 2019 map is has not yet been made.
11 map, let us see.
It is not there. 11 map.
11
I
map
have
is
not
also
seen.
not there?
I have not seen. No one has seen. I will show your lordships to the my lord the conclusions reached by the tribunal, and I have drawn your lordships' attention to kindly comes to 5.2. 5.2.4 6 temporary tourism facilities. This was not there in 2011. Now this has to be demarcated. That is why my submission was there before the tribunal that please wait till the 2019 map is prepared. If say for instance, after preparation of the
Even in 2025, if the 2019 map is not there, nobody knows when the map.
nobody knows. Nobody knows. I'll show the notice.
Map is also not there in front of you.
It is not there. It is not there. So therefore, I will show the authority who has been directed to prepare the map of 2019 is in the process. That is admitted in the tribunal order also.
But prior to raising any type of construction, be it temporary or otherwise, are you not required to obtain any permission from the Digha Shamkorpur Development
Digha Shamkorpur Development Authority is the implementing authority. It is their tender that we are implementing. The tender has been floated by Digha Shamkorpur Development Authority. Now, my lord, kindly, he is the licensee. Now, kindly comes to the 2011 map, lordship, 2011 notification, lordship wants to see once.
It's there. Yes, which portion?
The date.
Date is there.
16/11/2011. This has been superseded. And now kindly comes to the order of the tribunal. It has to be implemented first. Now, no. Prior to that, my lord, kindly sees the communication by which the authority has been directed to prepare the CRZ notifications. That is 233. 233, sorry. This is the affidavit.
Yes.
And kindly comes to, yes, 237. In supersession of ministries OM dated such and such, the institute agencies given hereunder are hereby authorized for preparation of upgradation of coastal zone management plans, CRZ MP plans, integrated such and such plans in consonance with the provisions of CRZ notification 2019, that is consultative process, dated such and such. And number 5 is the Institute of Environment Studies and Wetland Management, Kolkata. They have been empowered for preparation of CRZ in West Bengal. Preparation of upgradation of plans by such and such. Now, they are in the process that will be also appearing from tribunal, sir. Now, kindly come, since lordship is holding that brief, Lordship may kindly comes to your Lordship's last order in respect of Mandarmuni matter. 300, page 300. So drawing inspiration from this order, I have made these submissions before the learned my lord National Green Tribunal. Paragraph 4 bata কালকে আমজাদদা বললো না বসে বলতে হয় primary contention of the petitioner is that the CRZ notification in respect of state of West Bengal is yet to be published. In absence of CRZ notification, same cannot be implemented. Next contention, the NGT could not have delegated its authority to adjudicate upon a committee. This is also in my case, who subsequently passed the order of demolition. Further submission in the cause of action arose long back. That is their contention. And contention is that matter is yet to be heard. Oi arakta kothay laglo. As the matter is immediate threat of demolition, Lordship was pleased to mala. This is returnable before a Lordship any day. I can show from the order of the National Green Tribunal in respect of this Vishnupada Pakhira that it was the submission ber korota. Now kindly comes to, which is there quoted in the tribunal order also, kindly comes to the order of the tribunal now. Volume 1. I'll not, my lord, bother your Lordship to take your Lordship through entire 70 pages. If your Lordship wants, I can just, my lord, it starts from page 64. It starts from 64. The tribunal, my lord, records all the notifications, sets out everything there, and my lord, the relevant parts, it is the committee report is also set out here. The relevant parts which my lord, which relates to me starts.
I just want to see from the authorities the map where there is the boundaries have been set as to which will be the CRZ zone and which will be outside.
Which my learned friend has also pointed out, which was by the CRZ Management Authority. We have stated that the map is not ready.
Not ready. Then how will you get to know that which area falls within the CRZ zone and not?
Because CRZ MP, what he is emphasizing
Yes.
upon, which is very much needed to demarcate, it is not ready. I will be very, very candid with the authority. It is in the process of being prepared, but it is not prepared. And it is also in the affidavit of the
Before the tribunal.
Yes, before the this point has been taken.
Now,
how is the tribunal
maybe I was going through cursorily, not cursorily, I was going through the tribunal's order. It has
how has it dealt with it?
127.
Yes, it has dealt
Page
with
127.
One CRZ, all these areas, but I don't.
My lord, the tribunal in paragraphs, my lord, first I should, my lord, draw your lordship, otherwise it starts from paragraph 59 onwards, which says, paragraph 60 onwards, which says that on the basis of report, so far as the construction of amusement park is concerned, the such and such has filed the committee report of the committee constructed by this tribunal. Perusal of the report would show that the alleged resort in Deusagar having rooms constructed over the existing toilet complex and shops lies within CRZ 2.
Where from is the court getting to know this?
From the report. From the report, it says so. Which I have placed before your lordship. Kindly see paragraph 60. Paragraph 60, page 122. Lordship is there. Lordship is finding the committee report. I'll just point out. 267.
Yes, 267.
This is the committee report which is being relied upon in paragraph 60. Entirely copy paste. And even though in construction in CRZ 2 has not been directed to be demolished, only CRZ 1A.
The closer it is to the sea, the demolition should be there. One which is farther away can wait.
According to the tribunal, CRZ 1A. That is the demolition order, which I have, my lord, drawn your lordship's kind attention to in the first.
Is anybody there for the respondent number 12?
Okay, 12. Okay.
The Central Pollution Control Board.
The Bihani was appearing last time.
No, he's for the Dighar Shankarpur
Yes.
development.
Someone from the Union of India
Yes.
will take care.
Has to be.
Yes, has to be.
National
Central board
Center-
will also not be able to assist. Any case, lordship wants.
The National Center for Sustainable Coastal Management, Ministry of Environment, the
Ministry of yes, yes.
Union of India,
Union of India.
both.
Appeared before the tribunal.
They had appeared before the tribunal. They have been served also.
Is there any learned advocate representing?
No, before the tribunal.
Yes.
Shivajyoti ache na?
No, Sivajyoti.
Okay.
NT.
Rajiv Rai. In virtual mode.
They filed an affidavit also.
They have filed the affidavit also.
Why
May I
did you
just
serve
yes,
them?
may I just finish my lord, with the judgment, my lord. We have served. Kindly comes to page 60 where I was placing. Page 60.
No, but then what is to be done now?
Well, I'll be praying for my lord.
Same order that has been
Yes,
passed in
yes,
the
yes.
other matter.
Yes, yes.
Because the map is not there.
Map is not.
How can it be identified? The
I have
place?
additional grounds. The additional grounds in my case is that the committee report, which has in turn relied upon the CRZ status report, is not there in the record itself. I would have understood it is there somewhere in the record. I have not been given copy and all these things. But principles of natural justice violated. If that
Committee
is not
members are not a party over here.
no, committee members may not be party. They are.
But then the records should be here before the court. Otherwise, how will the
It
court
was not
decide?
there. I specifically argued this point. It was not there, though it was subsequently not recorded, but I had argued.
The committee was from, we were not there also.
And we were implemented, my lord, on 4th July
Be
2024.
representing the state.
My lord, I beg to represent the state lordship.
It is the state authority who has issued this
Lord, before my lord,
expression of interest.
before your lordship enters into this question,
Yes,
may I
dear.
respectfully, my lord, there is the point of entertainment of the writ petition. My learned senior friend was referring to some Madras Bar Association judgment. I don't know, but I am, my lord, armed with a judgment, a constitution judgment of 2020, my lord, volume, my lord, 6 SCC, my lord.
না এটা কবে কার আমার ম্যাড্রাসটা কবে কার
2020 volume 6 SCC,
ম্যাড্রাস
my lord,
is
page 1.
2022 ওরা হয়ে গেছে
My lord, it's a constitution judgment. In paragraph 12 of the said judgment, my lord, Honorable Supreme Court takes note of as many as, my lord, 24 acts, including NGT acts, in which, my lord, appeal to the Supreme Court is directly contemplated. The Honorable Supreme Court has taken note of this particular matter. And finally, in paragraph 200, after saying this, Honorable Apex Court says in paragraph 233 concluding part, there are so many sub-paragraphs of paragraph 223. Finally, 223.8 says, the central government in consultation with the Law Commission of India or any other expert body shall revisit the provisions of the statutes referable to the Finance Act 2017 and other acts as listed in paragraph 200 of this order, and place appropriate proposals before Parliament for consideration of the need to remove direct appeals to the Supreme Court from orders of tribunals. A decision in this regard by the Union of India shall be taken within 6 months.
Has the decision been taken?
Well, this is what I find from this judgment.
No. The concluding part you
Thereafter-
read out.
This is
Within 6
Sir.
months. Within 6 months. So thereafter, this matter was disposed of by the Honorable Apex Court. So what is the subsequent development? My learned
You do
senior
not
friend is
know.
referring to some 2022 judgment or
This is, my lord, Madhya Pradesh High Court Bar Association. Kindly, may I just read out? I think it will be, my lord, it will be sufficient. Now, what happened here? The Madhya Pradesh Bar Association filed an application, Article 32 petition before the Honorable Supreme Court, saying that you should shift the National Green Tribunals to Madhya Pradesh so that they also get the opportunity to appear before, because National Green Tribunals are having 4 or 5 states under there. So they challenge the provisions of the act. Now, my lord, while doing so, my lord, this question came to the, my lord, fell for consideration before the Honorable Supreme Court as to whether, I am now quoting A, whether the NGT outs High Court's jurisdiction under section 14 or 22 of the NGT Act. 14 is, my lord, the 22 is the 14 is the original jurisdiction which is being exercised by the NGT. 22 is the appellate jurisdiction which is before the Supreme Court. That too on the basis of substantial questions of law. Now may I just read? In so far as contention of the petitioners that there is outside of jurisdiction of the High Court under Article 226 and 227 of the Constitution because of section 14 and 22 of the NGT Act, it must be recalled that L. Chandra Kumar versus Union of India, it has been categorically declared that the power of judicial review under Article 226, 227 and 32 are part of the basic structure of our Constitution and the same is inviolable. The following pertinent position options rendered by such and such 7 judges. Thereafter, my lord, L. Chandra Kumar quoted. Thereafter, my lord, the finding starts. Apart from the clear enumeration on the legal position to the effect that NGT is within the purview of Article 226 and 227 jurisdiction of the High Court, the learned Attorney General on behalf of the Union of India has also made submissions consistent with L. Chandra Kumar Supra and concluded and consented that with the legal position. It can further be noted that in terms of the above ratio, L. Chandra Kumar, the High Court has been entertaining petitions under Article 226, 227 of the Constitution of India against orders of NGT. While exercising such jurisdiction, the court necessarily exercised due discretion on whether to entertain or to reject the petition as per the test broadly laid down in Whirlpool. Now kindly comes to the ending part, where it is the concluding part of this judgment, where yes, paragraph 45. In consonance with the above analysis, our conclusions are A. National Green Tribunal under section 14 and 22 of the National Green Tribunal Act does not outs the High Court's jurisdiction under Article 226,
I do
227.
not need you can put it in the screen.
Yes. Acha. I don't know how to share the screen. Basically, I am also to some extent handicapped.
No, you read, I can hear.
In consonance with such that the National Green Tribunal under section 14 and 22 of the NGT Act does not outs High Court's jurisdiction under Article 226 of the 226 and 227, as the same is a part of the basic structure of Constitution. The remedy of direct appeal to Supreme Court under section 22 of the National Green Tribunal is intra vires the Constitution. 22 was challenged. Section 3 of the National Green Tribunal is not a case of excessive declaration. That is not. And last is the seat of NGT bench can be located as per the exigencies, and it is not necessary to locate them in the every state. The prayer of the relocation of Bhopal NGT to Jabalpur is so therefore that was the prayer. Same case in respect of NCLT and all these things. Everywhere we come up, my lord, say that we should not be shifted. Now, my lord, we went up to the division bench, saying that this is the judgment. Since L. Chandra Kumar says division bench, so division bench. That is the logic that we went. Now, my lord, in that, by an order 28/11/2022, by the Honorable Chief Justice Prakash Srivastava and the Honorable Sri Rajeshri Bhardraj, my lord, records. This is public interest litigation filed by the such and such challenging judgment of National Green Tribunal. That was public interest litigation. So therefore, scope is wider. This is not public interest litigation. This is adversarial litigation. In respect of plying of private buses, it is not in dispute that in terms of the judgment of the Honorable Supreme Court in the matter of Madhya Pradesh High Court Advocate Bar Association and other versus Union of India reported in such and such, petitioners have a remedy of filing regular writ instead of appeal. In view of the fact that the petitioners are personally aggrieved with the judgment of the tribunal, we permit the petitioners to withdraw this case, public interest petition, with the liberty to file appropriate petition under Article 226 to 227, raising the personal grievances, which will be listed before the appropriate bench as per roster. So therefore, single bench. And my lord, after following this, my lord, the coordinate bench, my lord, presided over by the Honorable Justice Shobhashati Bhattacharya. I know that order because I had the occasion to address the court. we had, my lord, moved writ petitions by which the Honorable Court was pleased to, my lord, go into the issues of jurisdiction of the National Green Tribunal and remanded the matter back to the National Green Tribunal. Thereafter, the National Green Tribunal, without following the observations of this Honorable Court, has passed an order which also is impugned before your lordship, which is item number
1260.
1260. My humble submission is, my lord, these matters, my lord, this is, I'll be praying for an order, my lord, as it has been passed in the previous matters. my lord.
Lordship, so far as the judgment which my learned senior friend is citing with your lordship of 2022, my lord, Roser Metho, my lord, has not been taken into consideration. It's a constitutional judgment. My lord, secondly, my lord, here, my lord, L. Chandra Kumar has
No,
been
but then
taken.
this judgment does not lay down anything. It only gives proposal to the Union of India to get that
But since
removed.
direct
But
appeal to Supreme
thereafter,
Court was a point to be considered, and lordship kindly sees the after paragraph 200, kindly sees the observation, my lord, which the Honorable Supreme Court, that this should be deprecated. This kind of a statute should be turned down because direct appeal to Supreme Court should not be there. My lord, they are discussing the entire thing. The Honorable Appeals Court is discussing.
very well. So direct appeal will not. No, direct appeal will not. Let me understand. So direct appeal, the Supreme Court is not allowing. Where will the litigant go?
Direct appeal
As
is
on
there.
date, my lord, whether Section 22 has been taken care of or not, direct appeal to Supreme Court, it is not clear because the judgment which my learned friend is citing, my lord, there also L. Chandra Kumar was taken into consideration. This judgment which my learned senior friend is placing is basically on L. Chandra Kumar and 1998 8
Hey, Dada.
SCC Volume 1, that is Whirlpool. That is 4 exceptions.
What is
So,
this?
I mean, otherwise,
citation about?
L. Chandra Kumar also was taken care of in that basic structure.
That's citation about?
2020 Volume 6 SCC 1.
Yes, taken into
Constitution
consideration.
bench judgment.
It has been taken into consideration.
Constitution bench judgment.
It has been taken into consideration.
Kindly seize paragraph 200 to something.
With so many conflicting decisions, the
Paragraph
litigants will be left nowhere.
200 to 20.
This has been taken into consideration.
The
This has been
court will
taken
go on deciding only on the issue of jurisdiction and the parties will be remedial.
In fact, my lord, this is as of today, settled. Now, what happens is that this should have been in the what the union registrator tries to do.
I have followed
What
it.
the union registrator tries to do is, my lord, to bypass the state, my lord, the high courts, which should be deprecated in all my lord forums.
They have. Even the Apex Code also has deprecated this part.
This has to be deprecated. But
kind of
what can be done? We also appear for the petitioners challenging the order of tribunal of the orders of the DRT appellate tribunal, and in respect of consumer also.
And my lord, in deference to your lordship direction, the last occasion to me that Galip, you can come up with an instruction.
With?
In this matter, my lord.
Regarding what?
Lordship was supposed to direct me orally that you can also come up with an instruction in this matter.
All right.
So, my lord, I have come up with an instruction with the ADM LR, my lord, has given a very short instruction, my lord. Kindly seize, my lord.
Committee member, ADM LR.
Paragraph 2 by this.
The EOI has been taken care of.
No, he says that it is clear that responsibility avoiding all the it is one of the obligations of the petitioner to abide by the rules, and kindly sees the clause 2. As per available record, it seems that a petitioner was not called at the time of inspection by the committee, they say.
My case.
And with regard to the question raised about the publication of CRZ map, physical demarcation of so-and-so, CRZ authority is the appropriate authority to answer the same.
So it makes
And lastly is with common law. So, my lord,
But I can also place, my lord, the places where I have made the submissions before the tribunal.
they will see not test.
Page 127 onwards.
শুরুই তো করিনি। আচ্ছা। The direction passed by the National Green Tribunal. on 21st January 2025 in original application number 151/2022/EZ. In the matter of Subhas Dotto versus State of West Bengal and others, directing the respondent number 1 to ensure that all constructions which have been made in CRZ-1A as referred in the preceding paragraphs of the judgment and the prohibited area of para 8 within bracket small a II caps within bracket small I of CRZ notification, 2011 are completely removed and the area is restored to its original form. Stop. Such direction has to be carried out within 3 months. Stop. The specific contention of the petitioner is that as on date, there is no map which demarcates the coastal regulation zones. Stop. In the absence of a proper demarcation, the authority will the parties will not be in a position to ascertain as to whether the subject construction falls within the prohibited area or not. Stop. Paragraph. The impugned order was passed relying on a report filed by a committee constituted by the
Tribunal.
said tribunal. Stop. An inspection was conducted by the committee members without giving any notice to the petitioner. Stop. Reliance has been placed on an order passed by this bench on an order passed by this bench on 22nd November 2024 in WPA 27403 of 2024 within bracket Mandarmani Hoteliers Association versus Union of India and others, wherein the court took note of the fact that the CRZ notification is yet to be published, and in the absence of the notification, the same cannot be implemented. The prohibition cannot be implemented. Paragraph. It appears that in the instant case, the petitioner is running an amusement park relying on
The
a tender
tender is page 40.
which was floated by the Digha Shankarpur Development Authority on 4th of September 2020. Paragraph. Prayer has been made to stay the operation of the order impugned. Paragraph. None represents the applicant before the tribunal. Stop. None also represents the Central Pollution Control Board and the National Center for Sustainable Coastal Management. Stop. Next. Paragraph. Learned advocate representing the state respondents and the State Pollution Control Board submits upon instruction that the map delineating the coastal regulation zones are not readily available. Stop.
The state is not telling this, Lordship.
The map in terms of the notification published by the Ministry of Environment, Forest and Climate Change dated 18th January 2019 is under process. Stop. Next. Paragraph. An issue of maintainability has also been raised by the state respondents. Stop. Paragraph. As it prima facie appears that the map in question delineating the coastal regulatory zones is not readily available. Accordingly, it will not be possible for the implementing agencies to identify whether there is a breach of the prohibitions as laid down in the notifications published by the Ministry of Environment, Forest and Climate Change. Stop. Next. For the purpose of implementing the order passed by the learned tribunal, the zones are to be identified first. None is aware with regard to the limitation and the demarcation of CRZ-1 capse. Stop. In view of the above, it appears that there is practical impossibility on the part of the respondents to ensure compliance of the direction passed by the learned tribunal. The court, in the matter of Mondarmoni Hoteliers Association within brackets Supra, passed an interim order on 22nd of November 2024 restraining the authority not to give any effect to the impugned order of demolition. Stop. Paragraph. In line with the said decision, the said interim order, the court is inclined to pass an interim order in this matter also. Stop. Paragraph. The respondents are directed. Now, the direction passed in paragraph 81 of the judgment of the judgment passed by the tribunal in the original application is directed to be kept in abeyance till 30th of June 2025 or until further order, whichever is earlier. Stop. The respondents are directed to file their affidavit in opposition by 25th of April, reply if any by 8th of May. Released in the monthly list of June.
May
Released for
take back
hearing.
that instruction copy, Lordship.
Yes.
They will instruction copy the
Why will you take it back?
Since Lordship is pleased to direct a affidavit in opposition, do we?
File affidavit, there is hardly anything over here. And you'll get a photocopy again. I have marked it.
Lordship. After down.
Instruction forwarded by the additional district magistrate and district land and land reforms officer, Purva Mendipur, be written with the record.
Extra copy আমার কাছেও তো।
May it please your lordship to kindly take up this matter. Please your lordship, kindly take up the matter at 1:15. That I know it. I cannot withhold your lordship at 2. It's already 2. Your lordship must have some lunch. But if your lordship allows, then I can come back after your lordship again resumes after lunch.
What
I
is
was
the-
fixed on at ST certificate matter, my lord, which was fixed
Who's
at
your other side?
my lord, other side. We have put on notice. Mr. Dotto is here.
Ready with instructions? All right. Very well. 1 minute.
After you.
Mr. Lahiri, where is your report?
My lord, right now I have been given a CAN application by the petitioner. Right now.
Don't look at the can. Show me the report from the police.
I'm yet to receive. I'm yet to. I tell you, lordship, it is admitted in the application that police assistance was there.
Where is, I want to see
receive all-
something writing from the police.
Yes, I'm yet to receive, my lord.
Why?
I'm not yet, but I've communicated, my lord. I have not yet received. Now I tell you,
Let
lordship,
the officer come here.
My lord.
just give it 2
Because
days time.
the officer was present with
my
the
lord.
petitioner when he went
Yes,
over
my lord.
there.
On
I'm not
repeated
having- my lord,
occasions, I have mailed
just
the
a
officer. I have mailed the officer to help me out, but he was not there. And in connivance, in handling
may I
drugs
just
with the
say one thing?
respondent number
May I just
8,
say
they
one
have
thing? May I just say
deliberately
One
stayed not
minute.
helping
May I
me.
just say one thing? My lord, I'm yet to receive the report. I will appraise your lordship. Kindly give me 2 days time. Now I tell you, lordship, what happened. After that, they lodged an FIR against the petitioners. FIR has been lodged against them after they were restored to the flat. After that, as per lordship's order, we restored them. After that, this again started disputing amongst each other. Counter FIR has been lodged. So, my lord, I need to get hold of all these records and come before your lordship. And kindly give me 2 days time. I'll appraise your lordship in that.
My lord, let him come
Yes,
before the court
1 minute.
tomorrow, my lord.
What is your
His
instruction?
interest is not to be.
1 minute.
Lord, I have also received the CAN application today, my lord. Let me go through
No,
it.
no, you go through the can. Tell your mother and father to leave the house. Right? You stay there with your child. It is a matrimonial home, so you stay over there, but your parents should not be there.
Yes, yes.
Followed?
My lord.
Please come.
Yes.
My lord, in the meanwhile, one 35(3) notice has been issued against me.
That is the beyond the scope of this
My
petition.
lord, I just
You
want no
take
coercive
steps.
actions may be taken regarding that. My lord, I'm staying in
Take
Durgapur.
steps.
Yes.
Whatever notice has been issued, you respond to it.
My lord, I'm staying in Durgapur right now. I'm a senior citizen, 62
Yes.
years old, my lord.
Intimate them. You are communicating through mail.
Yes.
You intimate.
My lord, in the meanwhile, no coercive steps be taken, my lord.
Coercive steps are you
They have been
apprehending?
repeatedly being called by the police station, my lord. Your lordship can see that they have not filed the
All
report
right.
yet.
I'll take care of it.
Yes.
I'm obliged.
The fresh FIR has been lodged is beyond the scope of the writ petition. That I need to see
Achha.
what has happened.
Learned advocate for the petitioner submits that the respondent number 8 initially restrained the petitioner from entering into the subject flat. Stop. Thereafter, with the help of the police, the petitioner was restored possession. Now was put back in possession. But the respondent number 8, along with her parents, continuously disturbed and troubled the petitioner and forced her to leave the said house. Paragraph. Complaints were lodged before the police, but no action is reported to be taken. Paragraph. Learned advocate representing the respondent number 8 submits that the petitioner, that the respondent number 8 resides alone in the said house with her 7-year-old minor son. Stop. The petitioner picks up quarrel with the son of the respondent number 8.
My lord, the
Stop.
son doesn't stay here, my lord.
Son of the respondent number 8. It's your son.
Yes, 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 my lord. Sorry, my sorry.
The respondent number 8, it has been submitted that the respondent number 8 is not standing in the way of the petitioner to reside in the said premises. Stop. Complaint was lodged against the.
No, my lord, I have lodged an FIR against the petitioner.
Yes, complaint was lodged against the petitioner before the police, and the police has taken steps in response to the same. Paragraph. Learned advocate representing the state respondents submits that complaint and counter complaint has been lodged by the parties. Stop. The police has issued notice to the parties. Stop. Paragraph. Learned advocate for the petitioner submits that the petitioner is a senior citizen, aged about 80 years.
62 years.
Oh, 62 years. Who is currently stationed at Durgapur. Stop. The police is forcing her to appear in the police station. Stop. It is readily not possible for the petitioner to visit the police station. Paragraph. Upon hearing the parties, it appears that the parents of the respondent number 8 are residing in the subject flat. Stop. Paragraph. As the subject premises is the matrimonial home of the respondent number 8, comma, she and her son shall be permitted to stay over there. Stop. The parents of the respondent number 8 are directed to immediately leave the said premises. Stop. As regards the appearance of the petitioner before the police station, comma, considering the fact that the petitioner is a senior citizen, comma, the police shall permit the petitioner to appear virtually, and any inquiry or investigation that may be required, comma, may be conducted virtually. Stop. If physical presence of the petitioner is required, comma, then 72 hours prior notice shall be given to the petitioner.
Just one interjection. In the notice we have stated, hence you are asked to convey the suitable place. We asked them as per their convenience. It is not. Kindly see page 22 of the application.
Well, then the place can be in
It
Durgapur.
should be placed before by the petitioner fairly. Kindly
Next.
see.
I have annexed
The
it also.
matter,
Why did you make
No, I have
different
annexed it.
submission?
matter is made returnable on 8th of April. Stop. A police report shall be placed before this court on the adjourned date. Stop. The police shall ensure that there is no breach of peace in the subject flat. Stop. It will be open for the petitioner to return to her own place. And in the event she is being resisted, comma, the police shall ensure that the petitioner shall be permitted to return to her own place.
My lord, instead of 8, can it be on 9th?
It will be on the 7th.
Deeply.
Milady, just if I had followed wrong, your ladyship had issued that police issued notice regarding this my complaints to the police station, my lord. No notices has been issued
What is the
on behalf of
notice?
my
Kindly
complaint.
see,
my lord.
kindly see at the
What is the notice
section
for?
35 notice BNSS. I have
No, my lord, the
forwarded.
notice has been issued against me, but not relating to my complaint, my lord. Against them, no notice has been issued, my lord.
Whatever, some notice has been issued.
Yes, my lord. Against me.
That is the notice I placed before.
Very
Lordship.
But no steps had been taken in referring to my case, my lord, my complaints.
115 matter, I'll come up and take.
Petition.